much. So it struck me when I heard the last two papers is that you can change the name lawyers for consultancy firms and write exactly the same paper, okay? So in the case of a merger and acquisition, or in the case of new venture or capital raising, bonds, so on and so forth, the firm will go to a consultancy firm, to McKinsey, Beans, ask for an advice. That particular advice, the request will be preferred down within the firm itself. Eventually, some intern will write an advice, which will be exactly what the firm is asking for, okay? And the purpose of all this process, which is exactly the sort of things that you are talking about in your papers, is essentially to insulate all the players, okay? So in this case, management feels safer or insulated because they took advice. The bank who offered money is insulated because they took advice. And the result of this process, and I think they are similar in law, are two. That's what struck me, and that kind of the global picture, the bigger picture I'm trying to kind of come up with it, to see here. And that is, on the one hand, it's the law and consultancy firm and the what we call enablers are used part to insulate different actors from the consequence of their action, because at least in the case of merger and acquisition, in most cases, they know they're going to fail, okay? So they're used for insulation on one hand, and the second hand, we have kind of a whole professional services that essentially lives off commission, okay? And so we end up kind of a modern economy, a bit like the army, when you've got one soldier and 20 support staff. Ultimately, somebody's doing the job. There's somebody actually up there in the street who actually works, but that's one person. On top of this person, there are 20 and 30 layers of all kind of middle managers, consultancy, lawyers, accountants, who are living off that particular person.
Another question behind you?
Hi, I'm Eric Albert. I work for the French newspaper Le Monde. I just wanted to get an answer actually to the question asked earlier, but do lawyers take any risk whatsoever when they give those dodgy advices? I mean, it looks like from the presentation that in the US they are pretty well secure. Is there any example of, I don't know, in Britain or anywhere else? And do they take any risk? Because otherwise, whatever ethical guideline you can give, I don't think it will be very efficient.
Any examples of lawyers going to jail for the way that they've given advice to clients? Dan, have you come across any in the US?
I've come across some of the contrary examples.
Getting away with it. Fairly rare, I would say. I can't recall. In the tax planning, has any lawyer ever been, or even disciplined by the profession? Have any of these dodgy barristers ever come up against the Bar Council?
No. There aren't any formal mechanisms to confer risk on them, except for the possibility of a negligence action on the part of the client. So that's where insurance comes in. And
sometimes they get sued by their clients for giving duff advice.
But they're insured, and to that extent, I mean, as Ronan says, they're a mechanism for sort of spreading risk. The only distinction I think I draw, and the reason I talked about the kind of cachet attaching to these particular guys is how they differ from sort of consultants is that the more authoritative you purport to be, the wronger you can actually be, and the more you can get paid for being even wronger than those other guys. Right, yeah.
Another question for you, Claire, from Slido. Have the requirements to report tax planning schemes?
Reporting requirements might help. There are already, I mean, there are kind of regulatory encroachments on this. So, for example, you can now in UK law, it's possible now to suffer a penalty for having given a dodgy opinion, but the extent of the penalty is, I mean, as well as other constraints that mean it's not particularly effective. The extent of the penalty is only not getting your fee. So you're not really taking risk.
But you don't get your fee.
Yeah,
You don't
there's no downside aside from effectively not getting your cut. That's the only. So there's no downside risk, if you like. But there are regulatory encroachments along those lines. I mean, policy is pointing in the direction of that kind of thing. It's just baby steps.
As I understand it, the most effective regulation in the UK has introduced is the requirement you pay the tax first, and then we'll argue about it later. I mean, the way a lot of these avoidance schemes work is that you've got nothing to lose. You try a scheme, you don't pay the tax until such time as maybe the revenue investigates it, maybe the court upholds it or not. But by reversing the burden and saying pay first and then we'll argue about it, that's been more effective, hasn't it?
Yeah,
Well,
definitely.
the big advantage of the more likely than not opinion is that it takes it off the criminal docket, puts it in the civil docket. So you wind up paying fines, but you don't go to prison.
Well, that's it, because you have to prove you knowingly broke the law to be charged with a criminal offence. We've got to, you again, impatient.
Thank you very much, Ewan Grant, former customs officer. I can assure you there are a number of cases, in the UK at least, of customs and tax officials who've been involved in dubious advice and who have gone to jail, very definitely so, although that's been typically for fraud rather than the advice. My question for Santu is, it is quite a serious one. In relation to the cases of links of academic or practicing lawyers with the Big Four, did the professional body or the university investigate whether there were payments or inducements and whether these were appropriate? And did the taxman look at the expenditure of the Big Four and see whether they'd been wining and dining the lawyers? When I have worked in European Commission tax advisory programs in other countries, the worst personal case I saw of corruption within one of those programs involved a senior Finnish public servant, which does rather show that if it can happen there, it can happen anywhere. Mrs. Lagarde's IMF might have a few serious questions to answer about that. Thank you.
And you've got another similar question there, Claire. Santu, rather. Were the academics paid to give that particular advice?
Well, there was actually many different lawyers and legal scholars involved in the case with different situations, and there was even the lawyers who were hired by the users of the avoidance scheme. They wrote articles in law reviews, and there's a code of research ethics in Finnish universities that you should disclose conflict of interest in all scholarly publications and media appearances, but there wasn't any disclosure of dual roles of any of the people involved. So, and I think there hasn't been any investigation to that.
Okay, and then to wrap up, we've got, I think, a very good question there from Jane, and I'll put it even more strongly. A more robust debate is needed. Why are lawyers so privileged themselves? Why do we hold this role of representing people in such high esteem? Maybe it's precisely because lawyers are everywhere, not only representing clients, but actually in legislatures themselves. Certainly the UK Parliament is dominated by lawyers. But comments from the panel on that more broad question about the overall status of lawyers, if you like, and whether that could be curbed.
I mean, for me, that's a technical question. Because if we were to do what's suggested in the question above, for example, requiring tax lawyers to file a report when they give advice on some aggressive scheme or something like that, that would, in principle, contravene legal professional privilege, but you would enact some kind of legislative basis for making that report that that meant that legal professional privilege wouldn't apply. You just...
Yeah, but we're being asked a rather broader question, is why do we hold this legal professional status in such awe? Should there be a broader public debate about whether there really should be such strong privileges for lawyers?
I'm not sure it is. It seems like it does seem like, I mean, I don't know if people do hold lawyers in awe very much.
Well, it's a kind of paradox. I mean, people make jokes. There was a lot of lawyer jokes at one period in the US, certainly. But on the other hand, the idea of legal professional privilege seems pretty sacrosanct. No?
I'm sure I've seen surveys saying they're the least trusted people behind politicians.
Absolutely. But that's a paradox, isn't it? On the one hand, they're least trusted. On the other hand, they've managed very successfully to defend, A, their legal professional privilege, B, a lot of dubious practices we've heard about, even in Finland, we say. So that seems rather paradoxical to me.
Well, is it overly simplistic to say that some of it has to do with the adversary process, that there's a balance on the other side? There is somebody making
Well, but then
argument
the
other
balance
direction.
isn't very equal, is it? Because the rich can afford the best lawyers.
Well, the government, when they're hiring prosecutors, have quite a bank of money to hire people as well. If you're in an antitrust action in the United States, going against the Attorney General's office is no joke.
But in the context of tax, as we've said, it's very difficult to prove somebody defrauded the taxman. It's fairly rare to get a criminal prosecution in tax, usually, precisely because the lawyers are involved. If you get this opinion, then, as you yourself said, it shifts it from the criminal to the civil context. And in that context, I don't know if revenue authorities have been having resources constantly slashed, especially since the crisis. Final one or two comments?
I just want to make a comment to Mr. Ostis. I think while you're right in saying that yes, in developed countries, prosecutors can be very well paid. I'm from ISLP, the International Senior Lawyers Project. My name's Gabrielle, and I work with developing country governments to provide legal assistance to counter exactly that problem. We have developing countries who, through no fault of their own, do not have the legal capacity to enter into level playing field negotiations with the huge multinationals of the world, the big mining companies. We exist purely for that reason, to fill that gap. And bearing in mind we're a charity, so there's a whole lot of contradictions there. So I do think that idea, that dichotomy between money and power at one end, and then trying to fix the problems that has created, is also on lawyers too. So I think it's just something that needs to be considered by the profession as well.